Madam Chair, I do have a comment. It's not just the length of time that it's taking for the licensees or applicants or people that have questions, members of the public, but it's also the number of communications that they are needing to have in order to get something accomplished. So, Mr. Olmixon, I have a question for you. What is it going to take to fix the problem for good?
Continued emphasis on every available alternative. We welcome any specific recommendations that you have, but I will tell you that our staff at every single meeting determines what we can do better.
That's the only time, or that's one of the most common times when commissioners get reached, when somebody cannot get through and get it accomplished on their own. I do have a suggestion. If we could put all the systems of TREC so that even your telephone and every one of the people that work for the agency, if everyone was on the same phone system, I can assure you that the phone calls would reach everyone on a timely basis. If we put ourselves at the same level as we put the public.
So your suggestion is that we put the entire staff on phone duty?
No, sir.
Okay.
That everybody has to wait for this, that everybody has to be on a system in which all phone calls that come in have to go through a main system. That way, we'll figure out a way to solve it if we are all in the same system.
We are on the same system?
No, sir. There are direct lines.
Oh, there are,
Yeah.
and they're available?
Yes, sir.
Correct. Okay,
So
I see.
People that have those direct lines can call people directly, but a member of the public does not have access to those direct lines.
Understood.
They have to go through a normal system.
Understood. Through the switchboard?
Yes, sir.
I got it. So publish
let's all be
our
on the
direct
switchboard.
lines is your recommendation?
If it's good for the public, it's good for us.
Publish our direct lines? Is that your
Yes,
recommendation?
probably. I don't know. That's up to you.
Okay. Well, I was just trying to clarify
You're the
recommendation.
administrator. I'm just saying, I know that if everyone in the agency was, including you, in the same system, the problem will be solved faster because it would affect the people that work at the agency.
Thank you very much.
Thank you, sir.
A question?
I do, if I may. Will you please let us know how long it's the average time that it takes to get a license for new applicants? I looked on the website and we don't have that information in there. And for both, for sales and broker and for inspectors. Thank you, Ms. Jackson.
Yes. Thank you. Is that a question? I'm sorry. It's going to vary because an application, each person that files an application with us, they have a year in which to complete all of the requirements. So there's a variable there.
So the question is, if you have everything in hand, they've done everything, how long does it take us to turn around and provide them with a license?
Okay, if they everything, I can give you a ballpark on that.
My question is for the agency, how long does it take for us to have all the documentation from any given individual, whether it's sales or a broker license request or an inspector, how long does it take us as an agency to provide them with a new license?
Okay.
That's the question. Thank you.
Again, they can submit if they submit everything to us, it's going to depend upon them passing that exam. That's the variable. Them taking and passing the exam.
And the background check.
And the background check, yes.
So how long would it take? Weeks? A month?
It could
2 months?
take weeks or a month. It depends on the individual.
No, but say you have everything. They've passed. They provided everything. How long does it take us as an agency?
If they've provided everything to us, the license is issued right away. I mean, it's auto-approved overnight as long as the background check has passed.
When do we order the background check?
The background check, once they go and get fingerprinted, right? When they go and get fingerprinted, they get fingerprinted through, I think the name of it is Morpho Trust. They get fingerprinted through that agency. It could take possibly 2 weeks for us to get the results from the FBI in regards to that. If there are no problems or issues with it, then they issue immediately. It's auto-approved overnight.
So much.
Any other questions?
I have a question for Madam Chair. I'm not sure who should answer this question. This is related to the Reserve for the Long-Term Facilities Master Plan.
Okay.
I'm in the Budget Committee, and would you please, or someone, perhaps Mr. Olmixon, can fill everyone, including the new commissioners, on the plan? And my concern is that we're holding 11 million and a half, and as of the last commission meeting, we had a budget meeting, and we are still not clear that we are going to be able to be approved for these facilities. And my recommendation is that we use the funds. We have the means, but we have the willingness to use them to improve and better the agency, not just the regulations that we seem to have gotten very good at coming up with regulation with this and a very extensive agenda, but perhaps we can also be really good at using that money to improve our help and reach out to the public.
I'll happily give an update, and even more so, I think if we put it on the agenda for consideration for the February meeting, get you a written report on the status as well. For those who may be aware, we had a bill this last session, and in that bill, we asked for authorization for the Facilities Commission to enter into a long-term ground lease with the Commission that would allow us to build a building there that we would then reside in. That authorization, for a variety of reasons, was taken out at the last minute before the bill was passed. We'll await the passage of authorization, hopefully in our sunset legislation in 2019, that would allow us to then begin the process of finalizing the plan and beginning construction. That's what the money has been set aside for, per this Commission's instructions.
I have further questions. How much did the Commission anticipate that the original building was going to cost? Had originally was a 2-story building that would cost about $15 million. The second, after the passage of the comprehensive master plan by the legislature for the Capitol complex, it was determined that in fact that building needed to be doubled in size. And so the latest estimate from the Facilities Commission for a 4-story building instead of a 2-story building is about $25 million. And so that requires us, because we only need half of that, to engage with partners for the other portion of the building. We have 2 other SDSI agencies who have expressed initial interest in becoming partners with us on developing that building, and they would bear the majority of that additional cost. So we're actually not that far away from the ability to be able to fund construction, if all works well, in about 3 years, with resources that we have available. How much do we pay in rent monthly?
About 420,000, I think, is the number, and I apologize for not knowing that off the top of my head. That's annually. Annually.
Thank you.
And if I may, I did find the amount that we have in office space and rent is in your budget, the $111,339. Not all of that is rent, and some of that is offset by the SWICAP.
Is it yearly?
Yes, that's an annual.
Thank you.
Thank you.
And that's a net number. We actually pay much more than that, but it's offset by we negotiated in our lease. We pay all the occupancy-related statewide cost allocation plan assessment is offset against our rent, and that number has been climbing significantly every year. And so it appears as if our rent is going down significantly every year. It's really the combination of the two that is our contractual obligation.
Chairman Jones, Education Standards Advisory Committee.
Good morning. I'm Susan Jones, and I'm chairman of the Education Standards and Curriculum Committee. For those of you that are new, just very quickly, we have been in place for 4 years. That leads us to where we are now, 4 years later. Our committee now has begun to review and discuss the possibility of some designation courses that would be hopefully approved by TREC.
This is for Chairman Jones. Commissioner Stevens.
Madam Chair, I have a question. I'm not sure who would be the person to answer this, but I have very strong concerns regarding what I just heard from the Education Committee, and this is regarding that TREC is now going to is planning on offering courses that will be TREC certifying people, that it will be no different than if we went to get a driver's license from the DPS and they offered their own driving courses.
These are not.
No.
These will not be TREC written classes other than the one which we already have in place, which is the pre-licensing property management. All the others they will get from other sources. We're just saying an X number of hours. We are not specifying courses.
Okay, because I really believe that the role of TREC is to promote growth, to give the tools to the people that are out there already providing this information, and to welcome any new ones, because we do need great providers, but I don't think that that is the role of TREC.
I don't either, and we're not doing that.
Thank you.
So, we're patterning this kind of like what the Bar Association does, where they can take X amount of courses in a particular subject by whatever providers offer them, and then they can claim to be board certified in that particular specialty area. We feel it is a protection for the public. That is why we're doing it.
Would the certifications result in a separate license?
No, we are not suggesting that. I mean, that
might be better. I'm just throwing this out. You know, for instance, if you ride a motorcycle, you know, you get a Texas driver's license, and then you get a little extra thing on your license that says you're qualified to ride a motorcycle. And I wonder if maybe our real estate license could be something similar.
Yeah, there was talk of that, and there are some states that do that, but we didn't feel that that was something that we would recommend.
I just wanted to point out that if TREC wanted to, if the commission wanted to require a separate license or a type of license for property management, commercial, anything like that, that would have to be a statutory change. So that would be something that you would want to discuss, that we would want to discuss with a sunset commission. But
are you making the report for the inspector committee?
Chair, Commissioners, my name is Tony Slagle. I'm the Government Affairs person for the Commission and the staff liaison for the Inspector Committee. The chair apologizes she could not be here. She's traveling, so she asked me to give her report for the Inspector Committee. So the Inspector Committee met in Austin October 9th to discuss inspector rules related to that were proposed at the August Commission meeting, and to determine if there were any changes needed based on the comments received on those rules. At the meeting, the committee reviewed comments that were received for proposed changes to the inspector financial responsibility requirements, which is 22 TAC 535-211, in particular the proposal to prohibit the defense within limits clauses in the insurance policies purchased by inspectors to meet the financial responsibility requirements. It was determined that these clauses present an apparent conflict to the statutory requirement that the insurance provide coverage to protect the public against violations of subchapter G, and so they recommended changes based on that. While the amendments are on the agenda today, the committee is recommending that the commission hold off adoption on those changes until the February meeting due to the concerns that the inspector industry has on those changes. This this will allow staff the time to address and do some research and address some of those concerns.
On behalf of this commission, to submit for adoption amendments to 22 TAC Section 531.20, information about brokerage services, to the Texas Register, along with any technical or non-substantive changes required for adoption.
Yes, ma'am.
To please remind the commission that these proposals affect the livelihood of the people out there on the field, that although for us, these are just pieces of paper that the people have to follow through, and this is going to involve some people making all kinds of changes.
No, if they are currently compliant, they don't have to make any changes.
Right. They
The
can
changes
leave it
from
as
the
is.
last meeting,
Yes.
make it, if they are currently in compliance with what was true before, they have an alternate way to do this now with fewer words.
It's giving them more options. And that's the change in what was proposed. Based on the comments, we listened to the comments that we received and are making this additional.
And we need to provide some stability in the field. A lot of the practitioners are, they are entrepreneurs. You have single mothers and fathers out there trying to make it. And the amount of regulation that we are producing, that just because it's proposed, it does not have to be approved. This is our role here as commissioners. And this is why I oppose it.
This is a broader option. Like, that whatever was true before is still true, and now they have more choices. So this is actually making it easier to be in compliance.
Although it may be, it's still confusing, and it is still, we need to provide simpler, clearer rules so that there is no question and people do not have to worry about are they in compliance, because it's not only we are producing too many, and for people to keep up with this, pretty soon, as some of the comments have mentioned, they're going to have to hire an attorney to tell them how to keep up with all these rules. And I speak on their behalf. Thank you.
Okay, all in favor say aye. We have a motion, we have a second, we've had discussion. All in favor say aye.
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 And opposed, no.
No.
One against, motion carries. Agenda item 15.
Agenda item 15 is discussion and possible action to adopt 533.3 filing and notice. The amendments were published in the August 25th issue of the Texas Register. The amendment extends the time the applicant has to request a hearing following notice from the Commission and clarifies the starting date for the statutory 2-year waiting period following denial before an applicant can reapply. The amendments were recommended by the Commission's Enforcement Committee. No comments were received, and staff recommends adoption as published.
Commissioner Stevens, are you willing to make this motion?
I'm going to vote against it, Madam Chair, so probably should not make it.
Okay. Commissioner Wilkinson, will you make this motion?
It is moved that staff is authorized on behalf of the Commission to submit for adoption amendments to 22 TAC 533.3, filing and notice as presented to the Texas Register, along with any technical or non-substantial changes required for adoption.
I have a motion. Do I have a second?
Second.
Is there any discussion?
Madam Chair, very briefly, I'd like to support Commissioner Stevens. I have no problem with this particular rule, but I've been sitting on this commission for about 4 years now, and I thought maybe at my first few meetings that we were going through some kind of substantial rule overhaul, and that's why we had changes. But every meeting we have a binder. This meeting we have 2. I agree that the amount of changes we're making to rules, while albeit maybe good changes, are significant, repetitively numerous, and I'd like us to try and streamline these procedures and think about whether or not the changes in the future are entirely necessary or not. In particular, as we continue to face repeatedly face a number of these changes every single meeting we have. So, Commissioner Stevens, I appreciate your comments. That's all I have right now.
Yes.
What happens, can you hear me all right?
Mm-hmm.
What happens if we delay the decisions on these for one more meeting to February?
We have even more in February to look at.
Yeah. Well, I would say on this particular rule, and it's a good policy discussion, and we can address it for each rule, but this particular rule is the one that's open, and this one is actually helpful to applicants. It clarifies that 2 years after their initial denial, they can reapply, and it gives them additional time to request a hearing. So some of the rules come about because of cases that we've had, and we're trying to make things easier and more transparent. And if it's, in this particular case, we had 2 statutory provisions that you could read it one way or the other, and we wanted to make it clear so that everybody understood what they needed to do.
Sure, and I have, and perhaps I shouldn't be making these comments during discussion of this proposed rule, because I have no problem with this rule. I think most of the changes we're making are fine to good, whether they're necessary or not. My comment was merely in support of Commissioner Stevens. I personally, her comments were well taken by me. It's difficult for me as a commissioner to keep up with the enormous number of rule changes that we have before us repeatedly, meeting after meeting after meeting. Maybe they're necessary, maybe they're not. I just encourage us to be as efficient as we can in reviewing our rules.
And possible action to adopt amendments to 534.3, employee training and education.
Ma'am,
Okay.
on B, please. The commission may spend public funds as appropriate to pay the costs associated with employee training, including but not limited to salary, tuition, and other fees, travel and living expenses, training, stipend, expense of training materials, and other necessary expenses of an instructor, student, or other participant in a training or education program. Training, and now we have deleted. Training or education shall be related to the duties or prospective duties of the employee. And I also bring your attention to D. I'm sorry, to D. That the executive director shall adopt policies related to training for commission employees, including eligibility and obligations assumed upon completion. And I have a problem with this commission delegating to Mr. Olmixon something that may be subjective. I think that the purpose of the legislation is to have 9 commissioners on this body so that they can make decisions. And I was born in Mexico. I grew up in a system in which this very type of decisions tend to procure sycophancy, and the culture is a culture of mediocrity, and merit is not necessarily favored. So people tend to want to guess the desires of the people that are making the decisions, and that's why I strongly oppose it.
Yes.
What would you recommend, Ms. Commissioner Stevens, what would you recommend we ought to do on this one? Just completely deny it, or?
I think that we should reconsider, and that people that work for TREC that should have the opportunity to have the necessary education. My concern is that they have scratched that the training or education shall be even related to the duties or prospective duties of the employee. So I have no idea what the relationship would be, and that's a concern. But the people at TREC should have the opportunities, but they should submit whatever request without concerning to, does Mr. Olmixon like him? Or perhaps they're shy, or just so that they have an objective opportunity to present their requests. So perhaps they should present them anonymously to the commission.
It's going to be hard to do because someone has to be in charge.
Well, perhaps we could have a committee.
Counselor, how do you do training right now?
We have, over the years, expanded the training available for all staff by tremendous. I mean, I couldn't even give you probably 300%.
And I say that it's, again, I am not opposed to the workers of TREC to getting the best possible education. What I oppose is the way to get the education, that we should not, I mean, the balance, the separation of powers. We have all taken an oath to uphold the Constitution, and the Constitution tells us that we should separate power, and that power should not be in the hands of any single person. And I should not have to tell you that because I know that you've studied the law and that you're familiar with the Constitution, and that's why I oppose it.
Redirecting them to that place. And as Mr. Omixon said, that we are required to do that by the government code already.
But perhaps we should have a commission and not just have it in the hands of just one person. That's my objection.
Right, and that's fine to have that objection. In terms of monitoring staff, that is something that is already given in the separations of power, if you will, to the commissioner, to the executive director, because it is his duty to be in charge of staff, their training, their performance evaluations, and their pay.
And he answers to us.
And he answers to...
Yes,
right.
but I do notice that this commission, through the executive committee, which right now only has you and Commissioner Arriaga, sometimes make decisions that really belong to this body, just like Congress cannot transfer their power.
Wait a minute. Executive committee cannot make a decision without it coming here. There's never a decision made in executive committee. There's a recommendation perhaps brought to this body, but there are no decisions made by any committee that don't come into the light in this room.
Perhaps you've made them, because the Sunset Committee report that we requested that perhaps we be present, that was at your discretion.
Mr. Arriaga was there.
Even the President of the United States has to go through the Senate to have ratification of his appointees. And I don't see what the problem is with this commission and recognizing that perhaps it's too burdensome, or perhaps we see this as a reward, and I oppose it. It just, in my opinion, it does not follow the Constitution, separation of powers.
We digress. I don't even know where we are. On agenda item 16.
I think you had a motion
and I had a motion.
So you have to have a vote.
Second, so now we need to have a vote. Okay. All in favor, say aye.
Aye.
And opposed?
Aye.
Motion carries. Whew. Agenda item 16.
Discussion and possible action to adopt amendments to 22 TAC 535.17 broker price opinion or comparative market analysis.
Any discussion?
Repetitive. This was discussed during the advertising rule and it was opposed. Now we're coming up with a different name, so I oppose it.
Thank you. Any other discussion? All in favor say aye.
Aye. Aye.
And opposed, no. Motion carries. Agenda item 18.
Discussion and possible action to adopt amendments to 22 TAC 535.65 responsibilities and operations of providers of qualifying courses.
Or non-substantive changes required for reproposal to the Texas Register for publication and public comment.
Second.
Have a motion and a second. Any discussion?
Yes, Madam Chair.
Okay.
I recommend that when this is reproposed, that to please take into consideration that we need to hold license requestants or petitioners accountable. That instead of going after anybody that's a provider, that it should really be their own responsibility. We should not be placing liability elsewhere. We do not have the ability to enforce. We have enough on our plate as to try to enforce other things. And what we're trying to do is that we're trying to cover too much and we're not covering anything. And that's, so let's keep that in mind when you bring this reproposal. Thank you.
Okay.
Is 19A?
19, yes.
19A?
19A is discussion and possible action to adopt amendments to 22 TAC 535.141, initiation of investigation. The amendments were published in the August 25th issue of the Texas Register, and they remove subsection A, which references the mortgage fraud task force that was abolished by Senate Bill 526 in the 85th legislative session. The remaining sections were renumbered and salesperson was updated to the statutory term sales agent wherever it appeared. No comments were received, and staff recommends adopting the amendments as published.
Madam Chair, I make a motion.
Okay.
That we do not adopt this rule because we are not a policing agency, and we are deleting that the commission may not conduct an undercover or covert investigation of a person under the act. And for that reason, we should not do this. In the history of this agency, we have always had the public initiate an investigation, and I move that we continue doing that. Thank you.
There's a motion that is not staff recommended. Do I have a second? Do I have a second? Motion dies for lack of a second. Do I have an alternative motion, perhaps, Commissioner Wilkinson, on page 563? Okay. Any other questions? All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item.
Discussion and possible action to adopt amendments to 22 TAC Section 535.191, Schedule of Administrative Penalties. The amendments were published in the August 25th issue of the Texas Register. Staff's recommendation is to adopt the amendments as published.
Madam Chair,
Yes.
I'd like to move that we repropose this. This, I do not agree with this because, one, the penalties are excessive, and two, because we could not apply the law fairly and equally to all practitioners, and it is going to, how are we going to select who we go after when it's so vast? And I believe that when we cannot apply the law fairly and equally, that we should not come up with this, because it's also, we need to focus on integrity, but not this way.
My response to that, Commissioner Stevens, is we are complaint driven. Generally, when we have a staff-initiated complaint, it is an application and it's a criminal background. But for the majority of the cases, Mr. Moore here, that's correct, right? It's we're complaint driven. So when we get a complaint is when we look into these things. Now, if we get a complaint, we can look at all of the violations that are there, not just the ones that consumer is naming, but
still, I still think that there's just there is a reputation of TREC out there from people, even though you all have been going out there. People have fear of TREC regulations, and they have also, I have heard people coming to me and asking me, what can we do? They feel like we are in a threatening position, and I don't think that that is the role of the commission. We are here to promote the growth of real estate, and the tells us, let us only regulate what is absolutely necessary and get out of the way. This is why people are still coming to Texas. But what we are doing in this commission is we are accelerating our conversion from Texas into what now is, in a few years, what we have known real estate to be. If we continue this route, the people that are working for themselves are not going to be able to hold their jobs because it's going to be too burdensome and too costly. That's my concern. So this is just one of the many regulations. And please, we swear an oath to be here. And I take this jury very seriously. And yes, the easiest thing to do is to just go along and, with all these proposals, but just because they're proposed, that does not mean that that is what I see that is the best for the public. And I do also have another request that from council, general counsel, that we just have the letters from the public, but that we don't actually have a summary, because, let us make up our own opinions on them so that we actually can make up our mind. Just to try to remain more objective, that the proposals are just given, and then we do what we need to do with each. Each of us is chosen for that very reason, because we're all different and we all see things differently. Now, some of us practice and we see different things and hear different people. That's all. Thank you.
can go back, because if we go back to the legislature and get it, you as commission members cannot lobby the Texas legislature. That would be something that we might talk to an association and see if they held the same belief and they could lobby, but you cannot lobby.
And
discussion and possible action to adopt amendments to 22 TAC 535.300 advertising by residential rental locators. The amendments.
A motion and a second. Discussion.
Madam Chair. that whenever we're making these rules, this applies to residential rental locators. A lot of people that practice real estate practice different areas of real estate, and we should have broad, general rules that apply to everything. So they don't have to decide, okay, this is for renters, or this is for commercial, or this is for real estate. What's good for real estate is good for Texas. And we need to stay clear and concise. And I vote against because I believe it's unnecessary. Thank you.
And 7, use of standard contract forms. The amendments were published in the August 25th, 2017 issue of the Texas Register. The amendments as proposed clarify when a license holder can hire an attorney to prepare a form for use of a license holder's clients, and specific disclosures such a form must contain. It further clarifies that a license holder cannot have an attorney draft a form that changes any rights, remedies, or responsibilities of a party contained in a mandatory use standard contract form or addendum.
How'd they come down on it? Are there comments in here?
I also would like to mention that the rules that we are proposing need to be necessary, and they need to be carefully drafted. Otherwise, they should not leave this agency. They should not even be proposed. These rules have been very contentious, and I would like to remind this commission that there was so much contention out in the field. For those of you, the public, you do not hear or listen to the people that actually practice, but these rules have been very contentious because real estate is, it deals with contracts, and it deals with unique properties, and the nature of the business requires attorneys and contracts, and we need to respect the freedom of contract. But also, I'd like to remind this commission that I don't know if the members of the public particularly are aware that the advertising rule, the one that before was so contentious that the associations had to get together and they had to go to the legislation and bypass TREC because we were about to pass a rule because they did not agree with that. And I think that we are at a point that I believe that this agency really is underestimating the power of the people we are here to serve. And I hope that this is a reminder. Thank you. Lewis, I'd like to say that the Texas Association of Realtors did not initiate this. The people were able to keep up with this. I was receiving phone calls right away about how bad this rule was. If this was a good rule, people would want it. I would want it too. And I don't think that we careless when we produce and we draft these proposals, that we should have to, I think it's really embarrassing, at least for me, that this commission proposes rules and then y'all, the chair and you and Mr. Olmixon, the three of you go on behalf of this commission and you negotiate with TAR. That's really embarrassing because if we have good rules, we should not have to resort to that. And there's no excuse.
Well, remember that we're balancing not just the needs of the license holders, but the consumer protection issue well. And TAR and other associations represent their members. This commission staff is in charge of consumer protection first and license holders second. And we try to do that in the least burdensome way to license holders, because we do believe with what you said that economic growth is important in this state. So
it's not just license holders. It's also protecting the freedom of contract and the freedom of the public to make their own choices, because perhaps, see, here's another thing. We've changed the word promulgated to mandatory. We should not have done that. There are so many things that we don't even have time to comment on this, that we should come up with the best, with the form and let the public decide. You have taken contracts and only you can decide what is best for you. And this is just what TREC has to say. But what if you want to have this home, your home for sale by yourself? You should have that freedom of contract and that choice.
Nothing in this rule prohibits that.
Well, and that's what I'm saying. It needs to be good. And if it's going to be good, it's going to also be good for the public. And the public needs the freedom to be able to do that. And if it was that good, we would not have had the contention. And the public is telling us, not just them as practitioners, but the public I mean, so I've read these letters, and I hope that the rest of the people, especially the members of the public, have also had the opportunity to do that. Thank you.
Commissioner Wilkinson.
I'd just like to comment that being new to the commission, I will tell you, it has been some kind of experience to understand what I'm getting into. I had no idea that I would receive so many comments, and I really listen to all of you. I hope everyone does, and I hope we take it serious because there is a lot of changes, and I agree with that. So I think that I appreciate y'all trying to work together to this conclusion that we have done today. Hopefully these are good and do not have unintended consequences, because she's right. That there's a lot of contention out there, and they're afraid, and they shouldn't be. We should want practitioners that want to be in real estate, want to serve the consumer.
Okay. Leonard, this is the time for paragraph 5. These, and let me just tell you, these are the contract forms. Just as a reminder for our new commission member, the Broker Lawyer Committee is a statutory committee that is required by the statute to recommend review contracts. This commission can either give a...
I have a problem with that very section, because we are adding the necessity of the seller providing notice. Notice can take time, and we are tying up this home. Yes, the seller has arrived, but also that brings obligations on the seller. And contracts is not, they have not been like that. The seller in the past, you're imposing another duty on the seller, which if he wanted to turn around and sell that home now because he acted in good faith, he's being punished. And the burden is on him, and he did not default. The burden should be on the defaulting party, which is the buyer. And for that reason, I oppose it. And there were some of the letters from the public that mentioned that we are adding an extra step. And we need to allow the freedom. Every transaction, if we let the market decide it, people can decide for themselves, and if they feel like they cannot do it themselves, they'll go to a real estate agent that will best help them. Our job is to give them the tools and get out of the way. Thank you.
And you are, like I said, it's a statutory body that creates these forms, and the commission can just vote thumbs up or thumbs down, but you may send comments to the Broker Lawyer Committee, and you can send them through me to
if you will please, because
I always give them to them, and they look at every single comment. I can attest to that.
Just because they're statutory, there's a way that we can do it, that we can still comply with the statute, but we still don't have to. I mean, this will be a very different contract from anything else, because no other contract other than real estate contracts would require the seller to provide notice, and that's unnecessary.
Just to explain what the Broker Lawyer Committee did, I sit as liaison to that committee, so I hear all the discussions and sometimes answer questions if I'm asked. The way that they set it up is if the buyer does not give the earnest money within the 3-day time period, then the contract doesn't automatically default. It's only when the seller gives the notice. So if the seller decides, I'm going to let this guy have a couple more days to see if he gives the earnest money, the seller can do that. If the seller wants to terminate because he's now thinking the buyer's not going to put the earnest money down, then, and is already starting their inspection period, then the seller can take action. But it is a choice of the sellers.
Okay, so I don't think it's a choice of the seller, because that's what this contract says. It says that the seller needs to provide notice regardless of the choice of the seller. So if I'm selling you my home, and I mean, I'm buying a home from you, you're going to have to chase me down. You're imposing that on all of them. And this is, I think that this is unnecessary. There's no reason for the seller. If you and I are buying and selling a car, you should not have me down to provide notice, because legally, if you cannot find me, if I'm gone, if I have no interest, you still obligated per the contract to provide notice. And if you, for some reason, can't get a hold of them, they could come back to you and say, hey, guess what? You still have liability because you did not reach me.
Right. We'll point out that the contracts have a notice provision, and and in the contract you state how notice is given, and as long as a seller followed that notice provision, the notice would be deemed valid. So again, the paragraph says may terminate the contract, but this is up for reproposal. So anytime to send a comment to me to give to broker lawyer, I will give it to them before their meeting in January. Did we find the date? January 12th. That's going to be a busy week. So as I said, right now the broker lawyer committee does not feel that they're ready to have you adopt. I would like additional public input on the additional changes that they are recommending.
We have a yellow piece of paper on this, Carrie, so I need you to sit down for a second and let me call Bob Baker up here,
okay?
Because I failed to call him up a while ago, and he may want to make all of his comments now. So I'm probably going to give you more than 3 minutes, like half minutes. Please identify yourself.
Bob Baker. I'm a broker in Collin County, and I've been a broker for 50 years. This summer I celebrate it. And Commissioner Stevens, I appreciate your comments about trying to help the people out there. When I first got into the business in 1966, we didn't even know there were rules. And it was chaos, because even the agents didn't understand what they were doing, and the public was a disaster. You're out selling houses. I mean, you're just selling things, and we're in such a better place today. It's still hard. It'll always be hard because you're dealing with people, but it's good where we are. So I appreciate your comments going through this. I do feel like that most of, like in the section we just dealt with, that it has been resolved. While I am a realtor, I'm not speaking for TA, I'm speaking for a broker. I've got 2 offices, and I'm responsible for about 650 plus agents, which means I have a lot of buyers and sellers and landlords and tenants that my agents deal with, and I deal with the challenges every day. I couldn't do what I do, we couldn't do what we do without the resource association, and frankly without TREC, because it's what keeps us going, it's what makes all of this work. I know we're going to pull back the contract proposals and have more public comment, and that's good. If it's not premature, if I'm allowed to make a comment on paragraph 5, we are the good guys in the business. Those of us who work in the business, who work hard at it, my agents, the first thing they're trying to do is build a successful business, comply with their fiduciary duties to the clients, and follow the regulations. But if they don't build a successful business, the regulations don't matter because they're gone anyway. And so we've got to stay on top of making this good for them. I think they're good agents. I think they're smart. But one of the proposals I see in paragraph 5 is if this stops, if this ends on a Saturday or Sunday or holiday, extends to the next day, it's terrible. I think it opens up a Pandora box. The thing that we've always been able to do is say, these are all calendar days, when it ends, and it's over. And now you're opening something up that's going to frankly confuse them. And there's enough out there confusing them. And it's just going to be a challenge. I'll send my, we have this public period, and Lori and I have already talked about that. And she said, no, I think we're okay. So, and I have great respect for her opinion. But as we work through that, and the real challenge, Mr. Stevens, as I look through, we've always had a challenge with the earnest money issue. And I see this right now. Many times our sellers are in contracts, and the buyer has no obligation to show up with the earnest money. And most of the attorneys agree as long as they show up by closing, that's okay. And that's a huge problem. I mean, the seller is at a significant disadvantage. We're not creating an obligation for them. We're giving them some rights. We're creating a line. It'll be interesting to see what the broker lawyer committee comes up with. I don't think this, as a non-attorney, makes us a earnest money contract. I think it simply establishes a timeline for something we've needed, and I think it's very important. I think a longer time frame is good, 4 or 5 days, get us past a weekend and a holiday or something like that, and be much better. I do have an interesting thought, though, when we look at what's in paragraph 5, the proposed, and it talks about, sell may terminate until the buyer goes ahead and deposits the earnest money, to me that kind of extends it a little bit. So while it doesn't obligate the or anything, gives him a timeline in here, and kind of think about it. But if the buyer, if it's 5 or 6 or 7 days later and the buyer still hasn't done it, the seller still has that ability to give notice and to terminate and go through that process. The only other thing in there that I understand from Lori Levy that's going to be looked at is we've got date as a defined term, and in my market area, easily 15% of the contracts, executed contracts sitting in the title company, don't have an effective date on them.
Just 15?
Well, I'm an optimist. And the challenge is, if we're going to define effective date as a defined term, what do we do when we don't have an effective date in the contract? But thank all of you very much for what you're doing. When I looked through the 864 pages, fortunately I didn't have to look through the dealing with the things that Mark Moore had to deal with. I just looked at these sections here. For you guys to take the time and the effort to go through what you do for us, thank you very much. We appreciate it.
For all you do, Mr. Becker.
Chair, I'd like to address him and just
Bob,
make sure that
she's talking to you.
Sir, I just want to make sure that you are clear that I am not opposed to that whatsoever. I agree with you, and totally when it comes to the earnest money.
Okay.
But what we have right now is working and it's good. If a buyer is interested, they're going to act in good faith and they're going to deliver the earnest money. I have no problem with that. My contention is with the seller being added an extra step, because now the seller is asked to give notice, and that is going to put the seller in a bind. If you cannot locate a buyer that is not acting in good faith, it puts the burden on the wrong person and the party that did not breach. That's my problem.
I can 5 subchapter R, and this is for Rule 535.211, professional liability insurance that provides coverage for violation of subchapter G of Chapter 1102. The amendments were published in the August 25th issue. The Texas Real Estate Inspector Committee previously recommended the Commission propose these amendments to clarify the minimum standards of financial liability that an inspector must maintain during the period an inspector is licensed. The legislature has enacted 1102.1141 of the Texas Occupations Code, which requires an inspector to maintain a minimum of $100,000 financial responsibility in the form of an insurance policy, bond, or other security. Commission. This is to provide for professional liability coverage to protect the public against a violation of subchapter G of Chapter 1102. The Texas Real Estate Inspector Committee has received several questions and comments on the proposed amendments and has requested staff to gather additional information before the committee makes a recommendation to the Commission. For this reason, the committee is requesting that the Commission table the proposed amendments until its next meeting in February of 2018. And that is staff's recommendation, that the committee table the proposed amendment February 2018 Commission meeting to allow further vetting of additional information by the Texas Real Estate Inspectors Committee.
Madam Chair.
Yes.
If I may make a suggestion. So we're requiring our inspectors, which we already do, to hold liability insurance with a minimum coverage of $100,000.
Statutory, yeah.
Correct. And this rule would clarify that they're required to hold a policy that does not contain any kind of eroding policy limits, which are provisions in insurance contracts that reduce your coverage available by any attorney's fees that are incurred in defending an inspector. And that makes sense, but I have the same question, and I'm glad we're tabling this, because what I would like to see us do is a couple of things. One is I'd like to see some kind of market survey to see what this would do to premiums. How much does it cost to go buy a policy that doesn't have eroding limits versus a $100,000 policy that does? Also, how much would it cost to buy a $300,000 policy instead of a $100,000 policy, even though that $300,000 policy might have eroding coverage? So if it's going to be more cost effective for our inspectors, paradoxically, to increase their coverage requirement, but allow them to purchase insurance that does have eroding limits, then that would make more sense to me than prohibiting them from purchasing or saying that coverage that does have eroding limits doesn't fit this.
Okay, that makes sense. And I'm going to let Mr. Slagle speak to this since he's the liaison to that committee.
Well, and certainly he can answer that, but I was in the meeting virtually, and that is the reason that they're asking for us to table this, because they ask for this research. But I think you being on the record for it is good.
And the only thing I'll say lastly is that it, unfortunately for our inspector members, that policies that don't have eroding limits are better for consumers. So that's a matter of fact. But Mr. Slagle.
Commissioner Turner, we are gather some information, the very information you're talking about, trying to get some idea of what the costs would be to the inspector community, the availability of the product out there. Those issues, you're absolutely right in terms of the higher limits. You know, obviously the issue is that by statute we're 100,000, so we can't require an inspector to go higher than that. The intent of the language that was proposed, I think, was to allow for inspectors to do that. That's why I think it says that it reduces the minimum coverage required. So that was the intent. It may not be as artfully drafted to do that, but the intent was to allow for, if they go above a certain limit, to allow them to have some leeway in terms of those types of clauses. But one of the issues is that the statutory language says that it's there for the to cover the protection. I have it here, but it's to cover. To protect the consumer against violations of subchapter G. So the sticky problem is any clause that erodes that $100,000 and actually pays for the benefit of the inspector through their duty to defend. There's an apparent violation in the statute.
I completely understand. I just agree with them that we should do a little study to see what the financial impact is on it.
I apologize if I gave too much information. I just wanted to let everyone know that that's sort of what the issue is here. So we are gathering information. I talked to several agents just last week and got some information, and we're continuing to do that. So thank you.
Okay, let's go ahead and put a motion on the table, and then I'll bring the speakers up. So, Commissioner Williams.
Move that the commission table the proposed amendments until February 2018 commission meeting.
Do I have a second?
Second.
Okay. Are you Michael Rucker or Don Nixon? Don Nixon, okay.
Yes, I'm Don Nixon with Southern Preferred MGA. We write a lot of home inspectors and are the largest producer of home inspectors in the state. I think you all probably have my public comment in your material there. And
please remind us of your comment, if you will. Yeah, so we have it fresh. Please remind us of your comment.
Yes, ma'am. In my public comment, I stated that I kind of gave you some boring background on why those policies are written the way they are. And presently, there is no professional liability that I can find that's not written on a claims-made form with defense cost within the limits. And Mr. Turner here made an excellent point a while ago. If you elect, I know this is going to come up again, it's being tabled today, it's going to come up again. If you mandate a policy that has defense cost outside the limits, then you are mandating a policy that presently does not exist. And it's going to cause a lot of turmoil in the market. I spoke with Mr. Slagle about this earlier. He's talked to an agent who talked to the companies. Yes, they could do it, and it might be this much money, whatever. I recently traveled to Atlanta, Georgia for the Professional Liability Underwriting Society meetings. I met with all of the syndicates at Lloyd's that back us. We are a cover holder at Lloyd's of London, and none of them liked it. And they all said, yes, in theory it's possible. We don't know how much it will cost. I can tell you today, based on what Mr. Turner said, I can tell you how much $300,000 of coverage costs with an eroding limit or with defense costs within the limit. I can tell we have rates for that. We offer up to $1 million, $2 million in coverage, and we have some very prestigious inspectors in Texas who carry those limits. The lion's share of inspectors carry the minimum 100,000 per claim, 100,000 aggregate limit coverage because they're small business people and that's what meets their needs. We have never had a claim go over $100,000. The biggest claims that we have had, and I think we had one reach about $85,000, and of that $85,000, about $60,000 or 65,000 was in defense costs, and the rest of it we finally threw in a nominal. The inspector really didn't err. We finally threw in some money to help the plaintiff finance their case against the seller who had, in all fairness, committed serious fraud. But anyway, I know this is going to come up again. I felt it was important enough that even though I had knee replacement just a few weeks ago, I wanted to come and just let you know, if you elect to go with we require 100,000 with costs outside the limits, you are mandating a policy that presently does not exist. I polled every company that writes in Texas. Like I said, we're the largest. You have Hartford and you have Hanover, which are admitted companies. You have Ace Westchester. You have AmTrust. You have us underwriters at Lloyd's of London. All of us surplus lines. All of us write virtually the same policy. So I'd really appreciate your time. I appreciate you letting me speak. I felt it was important enough. I know that y'all can't know everything about everything, but I hope you will read my comments. Thank you very much.
Thank you, Mr. Nixon. Thank you.
I do have a question, sir. Sir.
Mr. Nixon.
Yes.
If those limits were to be imposed at the rate that they would go, have you heard comments from inspectors? Because most of us practice real estate, but not inspections. We don't really know what happens. What I anticipate is that people will just leave the field because they would not be able to make it between Obamacare and the insurance. What are the comments you're listening to?
I think that there is some validity to your point, Ms. Stevens. We have had an extraordinary number of inspectors, retire, leave the business or whatever, unless there has been a lot of turnover in the inspector business. We have schools putting new inspectors out, Champions and others putting new inspectors out every year, and yet the number it's gone up a little bit over the last few years, but it seems to have been fairly static. At the low point, there was about 2,300 something licensed inspectors. I think now the number 9 years later is up to about 2,700, but there is a good bit of turnover, both from normal things, retirement, age and whatever, and there's just a lot of guys that just don't make it. They spend the money, they go to school and buy the insurance and everything that's required, and they don't make it and they have to go do something else. But any cost that you add to small business guy is going to hurt. Presently, the policy that we write runs about $900 a year, more or less. If we could get our underwriters to agree to the policy that y'all were talking about with the staying with 100,000, but with defense costs outside the limits, we estimated, my estimate was going to run it up about 30 to 40%. I think Mr. Slagle usually was 25 to 40%. The agent that you talked to said that if they would write it, so you would be taking, let's say, you'd be taking a $900 policy and turning it into about $1,200, and so
60. Yeah.
It could make the difference. You don't know.
Mr. Nixon?
Yes.
In your public comment, you anecdotally mentioned that you've never had a claim against an inspector in your practice exceed $100,000.
That's correct.
Is there a way for us to to survey other insurers or for us to gather that data in order? I know some of it may be confidential because of parameters of settlement agreements that are entered into in this litigation, but what I'd like to figure out is whether or not we're a solution looking for a problem here. Because if so, then we don't need to make this change. In fact, we may need to do the opposite and say that that if you have $100,000 limits, that's fine regardless of whether or not it's an eroding policy.
I have agreed. I'm going to provide our data to Mr. in order to help, and I'm going to provide it by the real claims paid and defense paid. We spend, I can tell you, there's facts of the facts. We spend 2 to 3 times each year on defense costs what we spend on actual claims. There are a lot of claims made against home inspectors for which they're not liable.
Sure.
Things that are underground, things that are behind closed walls, things that have been hidden by, and what happens in a lot of these cases, our first notice of a claim, the home inspector's first notice of a claim is process server knocks on his doors and hands him suit papers. Well, you get to reading the seller got sued, both agents get sued, and the home inspector, everybody gets sued at once, and then we'll find out who's what. And a lot of times we end up contributing some nominal amount after spending a good defense just to get the home inspector out of the box.
It seems to me if you're the rare consumer who has an issue in which one of these policies being an eroding policy would matter,
right?
You're probably going to be SOL, pardon my language, if it's going to be well over $100,000.
Right, and the reality is when you think about it, things can happen. There's just not a whole lot. The E&O portion, the professional liability portion of the home inspector's policy, really is something down the road they find, and I suppose in theory they could find a $100,000, but typically the claim that a home inspector is really seriously liable for is going to be in the 10 to 15 to 20,000. One down in Houston recently, and legitimate claims, we pay them as fast as we can because they don't get any cheaper. And we had a claim in Kingwood, Texas, fairly recently, where the inspector, a reasonably new inspector, missed. There was an issue with some windows. There was, and they said we owed it. I paid it. I can't tell you everything about it. We use independent adjusters. We use our attorneys and whatever, but it had to do with the height of the windows. The code had changed, and there wasn't safety glazing in some of the windows. It was a deal. It was an $18,000 claim, which is a fairly substantial claim. We paid it real fast. They said we owed it. The adjuster I sent out said, "Hey, here's what it's supposed to be, and here's what it is, and these windows aren't high enough, I guess, for people to safely egress from the home, and they're supposed to be this, and this door is supposed to have safety glazing in it," and whatever it was. And that's a typical claim. Or a roof. We had one just last week I paid.
Okay, let's kind of wrap it up. Let's kind of wrap it up.
Any of that kind of stuff, and that's a typical legitimate home inspector claim. Your odds of having a $100,000 miss are fairly small.
Tony, will you see if you can find some information on that too? Typical size of claims in inspector cases.
Right. The
typical. Will you see if you can find some information too, in addition to what Mr. Nixon's going to provide? Hang on, Mr. Nixon.
Y'all can get together.
Yeah.
Thank you, Mr. Nixon.
Give you the list of companies.
Give them to Mr. Slagle. Great. Thank you.
Thank y'all for your time.
Take care of your knee. Wait a minute, Curie. We also had a Michael Rucker down for this item. Is Mr. Rucker still in the room? Mr. Rucker gave us up. Okay. Where are we? We need to vote on the table, right?
We have a motion. We need to vote.
We need to vote on the table. All in favor of tabling this, say aye.
Aye.
And opposed, no.
Aye.
The ayes have it. So now we're 26B.
The good news is
the rule review process. Every 4 years, we're required by statute, by Chapter 2001 of the government code every 4 years to review all of our rules.
To assure the commissioners that one of the focus areas for this particular rule review is precisely what Commissioner Stevens and others have echoed, which is to look for places where we might remove unnecessary burdens from the rules. Not just insert clarification, as is often the reason for promulgating any rule is to clarify something that came up from either a SOA decision or the industry or complaint case that we get complaints about things and people say, well, I didn't know that. It's not clear in the rule, those kinds of things. But in this case, it is absolutely appropriate that we sharpen our eye to look for areas where we might remove unnecessary burdens that don't pass the balance test. It places a burden on the industry and does not result in a commensurate increase of protection for consumers. That is one part, that balancing is one part of our mission. So that's what I've asked the staff to do this time.